Hello everyone, welcome to MastersTeach, and today we'll discuss public international law. Okay, simply we say this as a PIL. Okay, we'll discuss detailedly. So listen again and again so that you will clear your exam easily. Okay, if you spend 20 minutes on this particular video, so it will be easy for you. Then, what is the definition, nature, and scope of public international law? So, as per Copenhagen, so public international law is a set of rules that countries follow their dealings with each other. So, as per the Spark, public international law is made up of rules that states feel they must obey. Briefly, so rules that bind civilized countries in relationship with others. So let us discuss difference between public versus private international law. Let us see public international law. So the PIL is between the countries, whereas private international law between the individual persons. In public international law, we use this treaties, whereas uh, private international law, which is conflicts of law. So, the public international law decided by International Court of Justice, whereas private international law decided by domestic courts. So, this is the thing. Let us go to the next slide. International law and municipal law. So, municipal law called as domestic law. There are two major theories. One is monism and dualism. What is monism? It is the international law, and municipal law, that is domestic law, are one single legal system in which international law is superior. Whereas in dualism, as per the dualism theory, it is the international law and municipal law are two different systems. So international law must be converted into domestic law is to be applied. So let us have difference between monism and versus dualism. So here in monism is only one system, whether it is municipal law or international law is one system, whereas in dualism there are two separate system. So international law is different and municipal law is different. So which is the superior, whether it is monism or dualism? So in monism is international law is supreme, whereas in dualism, where it is municipal law or international law are equal. So where it is applicable directly. Okay, whereas in dual law, it is needs transformation. So key thinkers for this monism, it is the Kelsen and Letter Pact. Whereas dualism, the key thinkers are Triple and Ancelotti. So in India we follow dualism. So international law must be enacted by the parliament to become law. So we follow dualism in Indian parliament or Indian law system. Okay, let us see what is the source of international law. So as per the article 38 of International Court of Justice, so these are the statutes, these are the source for the international law. One is treaties and convention, and second one is international customs. Third one is general principles of law. Fourth one is judicial decision and writings. So what is treaties and convention? So it is a written agreement between the countries. Okay, example UN Charter. Okay, international customs. So long standing practices accepted as a law which increases the domestic immunity. Whereas general principle law, so common legal principles recognized by the civilized nation, that is general principles of law. Whereas judicial decisions and writings, so judgment of International Court of Justice and writings of the top scholars. So these are the, when they ask what is the source of international law, you have to write is treaties and convention, international customs, general principles of law, then judicial decisions and writings. Okay, many times it is asked, you have to remember. Then uh, let us see what is codification of international law. So what is codification? Converting unwritten customary rules into written organized form. So making law clear and more predictable. So in simple what we say that some of the laws followed, some of the rules all followed in different countries. So which is not written. However, when they are written in a book in a organized form, so making law, so it makes clear and more predictable. That is codification. So who does this codification? Who write these unwritten customary rules? One is ILC, that is International Law Commission 1947. It is a United Nation body. And one more thing, so who reads like VCLT 1969, it is a Treaty of Threats, and UNCLOS 1982, it is a law of the sea. So these are the codification, and which bodies prepare? These are the bodies which prepare. What methods they follows? So one is official and second one is unofficial. Official means by international bodies like International Law Commission, under which is under UN authority, whereas uh, this codification done by the unofficial, by the scholars or institutions, influential but not legally binding people. These are the things. So the codification you understand, what is the bodies you understand. Okay, so ILC is what? International Law Commission. It is the main United Nation body which codifies international law or which writes international law. Okay, then we'll go to the next slide. State recognition. State recognition. Yes, we'll see about the state recognition. Okay, there are two theories of state recognition. One is constitutive theory, another one is declaratory theory. And what constituency theory says that recognition creates statehood. A state exists only when other states recognize it. Okay, so which is based on the thinkers like Oppenheim and Ancelotti. Whereas declarative theory, which is recognition only declares what already exists. So a state exists by fact, not by the recognition. So which, like this is given by thinkers briefly Hall. There are two types of recognition of the state or country, de facto recognition and de jure recognition. What is de facto recognition? It is a temporary, unofficial recognition which can be withdrawn based on effective control, not legal legitimacy. And second type of recognition of a country, so de jure recognition. It is a full, it is a permanent, it has the legal recognition which cannot be withdrawn easily, which implies complete acceptance under international law. So, de facto means it is a temporary recognition, whereas de jure means in law it is a permanent, and India gave de facto recognition to Bangladesh in 1971. That means temporarily they recognized Bangladesh as a country in 1971. Then de jure, then after that, then it become permanent recognition. So I hope you understand this. Two theories of state recognition. One is constitutive theory, one is declarative theory, and two types of recognition: de facto recognition, de jure recognition. Let us go to the next slide. So, what is the state succession and state responsibility? I'll read out what is the state succession. Here, when one state takes over other territory of another, or governed by Vienna Convention in 1978, that is Treaties, and Vienna Convention 1983, it is the state separately. That is a state succession. So types of succession, like succession means somebody acquire the thing. Okay, one country acquire another country. That is called as state succession, and there is two types: universal succession. So one state completely absorbs another. So for example, Germany reunification in 1990, whereas partial succession. So part of the state breaks away. For example, Bangladesh from Pakistan in 1971. This is a partial succession. So, what is the responsibility when the succession isn't take place? Okay, here a state responsible when it violates the international law. So, the elements are an act or omission by state. Second one, the act must be breach of international law. The third one is the act must be attributable to the state. So, what is the remedies? What is the solution when the succession takes place? Okay, reconstitution. So, they are going to have original position and compensation need to be paid. Then apologies when the satisfaction is there, then that is acknowledgement. If the not satisfaction is there, then apology. There is a state succession and state responsibility. Okay, state responsibility not equal to criminal liability. It is in civil nature. So one cannot acquire any state with the criminality, but with the responsibility it can be done. Okay, let us go to the next slide. Position of individuals in international law. Okay, in historical position, individual has no direct rights under international law. Only states were recognized as a subjects of international law. That means in international law, individual has no priority, person has no rights under the international law. However, the states, the governments or the countries have recognized and they have the right to do. Then in historically it is happened, but in modern position, what is the international law? So individual has the right and duties under international law. So they consider human rights law, then international criminal law is there. So previously there is no rights for the human being. It is only up to the countries or the governments. But in modern way, in modern position in international law, human rights are considered. Human rights law is there. International criminals law is there. So let us see human rights treaties. Treaties means agreements. So one is UDHR 1948, that is a Universal Declaration of Human Rights, whereas ICCPR 1966, that is a International Convent on Civil and Political Rights, whereas ICESCR 1966, that means International Covenant on Economic, Social and Cultural Rights. What is covenant? Covenant means it is an agreement. So remember human rights treaties, Universal Declaration of Human Rights 1948 and International Covenant on Civil Political Rights 1966. Then International Covenant on Economic, Social, Cultural Rights 1966. What is the individual responsibility? Okay, individuals can be tried for war crimes, genocide, crimes against humanity. So, as per the Nuremberg trial 1945, then it is there in International Criminal Court. Okay, what is Nuremberg trials in 1945? It is the first time individuals were held responsible for international law. Okay, let us go to the next slide. Extradition and asylum. What is extradition? That means handing over a criminal or fugitive one from one country to another based on treaties or reciprocity. Okay, extradition means the criminals will be handed over to the another country, from one country to another, so which is already based on treaties, that means which is based on already written agreements. Reciprocal means uh, criminals can be exchanged or sent to the particular country. Okay, what is asylum? Okay, it is a protection given by a country to a person fleeing prosecution. Okay, there are key principle for this thing. There is a double criminality. The act must be crime in both the countries. If the person done some crime in both the countries, that is a criminality. Then political offense exception. So political offenders are not extradited. That means they are not taken. Then specialty rule. So person can only be tried for offense they were extracted for. Then types of asylum. Okay, territorial asylum and diplomatic asylum. So given the within the country own territory, most common form territorial asylum, whereas diplomatic asylum is given an embassy or consulate. There is a Latin American practice. So as per the Article 14 of UDHR, that is a Universal Declaration of Human Rights, right to seek asylums. So extradition means one has to send back to the country where it is given. Okay, whereas asylum means giving shelter. Okay, somebody came from other country due to floods, due to war, due to fear of death, due to fear of like many things. So we give the asylum. There is a giving shelter. Political offender get the asylum, not extradition. So for example, Sheikh Hasina done something wrong in Bangladesh, and we have given as a asylum. We give the shelter, not extradition. So this is the thing: extradition and asylum. Okay. Then diplomatic envoys and law of treaties. What is diplomatic envoys? It is governed by VCDR, that is Vienna Convention and Diplomatic Relations in 1961. What is diplomatic immunity? So diplomats cannot be arrested or prosecuted in the host country. For example, different countries appoints their ambassadors or diplomats to other country where they cannot be arrested, and at the same time they are not be punished in the country where they posted. What is the different ranks of diplomats? One is ambassador, that is the highest rank, then minister, then charge affair. So these are the ranks. One is ambassador first, then minister, charge of affair. So maybe ambassador is the first step in the highest priority in diplomatic. Then it comes to the minister, then charge of international affairs, something like that. Persona non grata. So it is a person, it is a minister, it is a ambassador, a diplomatic declared unwelcome and asked to leave the host country. For example, one diplomat, one minister, one ambassador, they does something wrong in a country, then they are going to be they have to leave the host country. That is called as persona non grata. Then like law of treaties. This is a diplomatic of envoys, diplomatic of immunity. So that means they have the power. Nobody can arrested in the country where they uh, come for diplomacy. The ranks are ambassador, minister, charge affair, then persona non grata. That means, so this is a unwelcome, like they are sent back to their country, like ambassadors, ministers, who is in charge, they'll send back. That is called as persona non grata. Then law of treaties. So treaties means agreement. It is governed by VCLT. What is VCLT full form? It is a Vienna Convention on the Law of Treaties 1969. So the one agreement is done in Vienna country. Okay. So in 1969, a treaty means a written document, written agreement between two or more countries. That is called as treaty. What is the types of treaties or types of written agreements? One is bilateral, in which between the two countries, whereas multilateral treaties means between many countries, that is more than two countries. What is the key stage? What is the stages in diplomacy or treaties? Okay, treaties. First, they'll have the negotiation. Okay, our Prime Minister visit other countries, first they discussion, then make the signatures, then ratify. Then ratify means it comes to like that become legal, then enforce into force, entry into force. That means it is going to be action on that play on that particular thing. That is the key stages of treaties. Then practa sunt servanda. So treaties must be kept honored. The most important principles of treaty of law. That means whatever the treaties, whatever the agreements are made, that need to be honored. That must be keep for the future reference purpose. That is practa sunt servanda. So that is the thing. So what is practa sunt servanda? That means agreements must be kept. It is the most important principles of treaty law. Let us discuss Unit 4, Law of the Sea. Okay, so how the law is used when somebody uses the ocean thing. Let us read me this. UNCLOS, that means United Nations Convention on the Law of Sea 1982. What is UN? United Nations Sea Convention on the Law of the Sea 1982. It is called as Constitution of the Ocean, which came into force 1994, and India is ratified or involved in 1995. So what you have to remember, Law of the Sea, it is a UNCLOS, that is a United Nations Convention on the Law of the Seas 1982, is called as Constitution of the Ocean, which is came into force in 1994, but actually India joined in 1995. So what is the rights have different countries on the sea, up to what distance they can use. That is the thing. One is the zone. So the sea zone is divided into terrestrial sea, then contiguous zone, then exclusive zone, exclusive economic zone, that is a double EZ, then continental shelf, then high sea. Okay, so let us see terrestrial sea. Okay, so the country has up to the 12 nautical miles. There is a distance within the country. The country is nearby 12 nautical miles. Nautical means they like the distance is measured on the sea, that is called nautical miles. So they have the full sovereignty. So the country has the full power. So the country within the 12 nautical miles, they have the full sovereignty, full authority. Whereas contiguous zone, it is like 24 nautical miles. So where the customs, immigration will control. Whereas exclusive economic zone, okay, it has 200 nautical miles where they have the economic rights and fishing, minerals, extraction, etc. Then continental shelf, it is up to the 350 nautical miles. So it is subbed resource rights. Whereas high sea, okay, whereas high sea means behind 200 nautical miles, it is open for all the countries. So from each unit you will have one question compulsory. Try to understand. Okay, what is EEZ? That is a exclusive economic zone. India has sovereign rights over the up to the 200 nautical miles. This is the thing. Let us go to the next slide of your unit 4. high sea and common heritage of mankind. So, as per the uh, Article 87 UN clause, okay, navigation like ships of all countries can sail freely, okay, whereas overflight aircrafts can fly over high seas, cable and pipeline, freedom to lay submarine cables and pipelines, and fishing. So, according to the treaties agreement, the fishing can be done. Scientific research, okay, so freedom to conduct marine scientific research. Then, artificial islands. So, it is freedom to construct artificial island and installations. So, what is the common heritage of mankind? The, the deep sea bed, that is called the area. It is a source belongs to all of the humanity, not any one countries. So no state or no country claim sovereignty over it or power on it. So International Seabed Authority. Okay, what is CHM? That is a common heritage of mankind. What is international? What is ISA? International Seabed Authority, which governs the area, the which is headquartered in Kingston, okay, which is in Jamaica. It regulates deep sea mining activity. So International Seabed Authority, it is in Jamaica, the headquarters in Kingston. So that is the thing which regulate all the mining things on the sea. So it is also applicable outer outer space treaty 1967, the moon 19 the moon agreement 1979. So exam tip, what you have to remember, what is CHM? It is a common heritage of mankind. The deep seabed and outer space. So and the moon cannot be owned by any country. So you can, any country can go to the moon, and any country can go to the deep seabed and do the things. So these are the things you have to remember. Then legal regime of airspace. Okay, so every country has complete and exclusive sovereignty over the airspace above its territory. For example, India, on Indian map, whatever uh, like sky is there, airspace is there, it belongs to, it has a full authority over air. So what is the key convention or key meetings or key decisions? So like it is a Paris Convention in 1919. So it's the first recognized state sovereignty over airspace. Then Warsaw Convention 1929. It is a liability for international air travel. Whereas Chicago Convention 1944. It is a foundation of modern international air law. Whereas ICAO, that is International Civil Aviation Organization 1944. So United Nations agrees to regulate civil aviation. So there are two types of airspaces: national airspace and international airspace. What is national airspace? It is above country's territory and terrestrial sea. So it is fully controlled by the country. That is the national airspace. What is international airspace? It is above the high sea, open for all the countries. So just remember the things about the, we discussed about the territory, we discussed about the sea, we discussed about the airspace. Okay, just remember the things. Okay, what important point here? Chicago Convention 1944. It is the most important conventions of air law. That is a UN agency regulate the civil aviation, whereas ICAO, International Civil Aviation Organization, which is headquartered in Montreal, Canada. Okay, let us go for fifth unit, fourth unit. Okay, five freedom of air. Okay, so every country has the freedom over the air or over the sky. So which is established as per the Chicago Convention 1944. So these are the rights allow the airline to operate internationally. Flyover, technical stop, set down, pick up and carry between. What is flyover? That means it is right to fly over foreign countries without landing. So one country can fly over to the internationally without landing the flight. And technical stop. So right to land in a foreign country for non-traffic purpose. For example, refueling purpose. Okay, you can stop your flight in a foreign country. Okay, this is a technical stop. Then set down. So that means right to carry passengers or cargo from one country to another country. That is a set down. Okay. What is pickup? It is a right to carry passengers or cargo from another country and back to your home country. Then carry between. So there is a right to carry passengers as well as cargo between two foreign countries as a part of flight from to our home country. These are the things. So first two is the technical rights. That means flyover. You can fly, okay, without landing, and technical stop. So without passenger, however, you can refuel it. And the last three, there is 3, 4, 5. It is a commercial flights where you can pick up and drop the cargo with the passengers, etc. That's the thing. Then outer space law. Okay, so like space can be used anyone as per the different thing. We'll discuss what is it. Sputnik launched. So that Russia, USSR first man-made satellite, start of the space age in 1957, and in 1963 partial nuclear test ban treaty. So all the nuclear tests should be banned in space. There is a 1963 partial nuclear test ban treaty, and 1967 it is a outer space treaty. Okay, space is the province for all mankind. No country can claim sovereignty over uh, space or celestial bodies. And 1968 rescue agreement. So it is like countries must be rescued ostnants in distress. In 1972 liability convention, countries are liable for damage caused by space objects. Then it comes to the 1979 moon agreement. So moon and its resource common heritage of mankind. So the key principles of space law: no appropriation. So no national appropriation or of outer space or celestial bodies. That means nobody has control over that. Peaceful purpose. So space, our space should be used for the peaceful purpose, not for the war purpose or destruction purpose. Envy of mankind. So astronauts are envy of mankind. So everybody has to assist it and rescue. Then COPUS, that is Committee on the Peaceful Uses of Outer Space. So the key, which is a key United Nations governing space law. Let us see about the different international organization. It is a part of your fifth unit. Okay, What is the different organizations are there? Okay, or League of Nations versus United Nations. It is League of Nations and United Nations. So League of Nations established in 1920, whereas United Nations established in 1945. Then, like the League of Nations is started after World War One, whereas United Nations uh, started after World War Two. The headquarters of League of Nations, it is in Geneva, Switzerland, whereas United Nations headquarters in New York, America. Members, so it was 63 maximum in League of Nations, whereas United Nations it has 193 countries. So yes, India was member in League of Nations, is a part of British India. In United Nations we have the member of United Nations, then failed because so USA never joined, so no enforcement power. League of is why it is failed because United States or America never joined, so that is the reason it got thing. Whereas United Nation, which is stronger enforcement via Security Council. So United Nation has the main organs or main six branches. One is General Assembly, second one is Security Council, third one is Secretariat, and fourth one is ICJ, that is the International Court of Justice, whereas ECOSOC, that is Economic and Social Council, and Trustship Council. These are the six organs. Try to remember. Okay, one is what is the six main organs? One is General Assembly. It has 193 members of different countries. Okay, which discuss the world's issues. That is General Assembly. Security Council, which has 15 members and 5 permanent members: USA, UK, France, Russia, China. So in order to maintain the peace, so they have 5 major countries and total have the 15 members. Whereas Secretariat, it is the administrative body which has the head, which has the Secretary General. Okay, then ICJ, that is International Court of Justice, it is a judicial organ located in Hague. Okay, whereas ECOSOC, what is that? Economic and Social Council, which coordinates economic and social work. Then Trustship Council, suspended, it is in 1944. These are the six organs. Try to remember, try to write about the League of the Nation and United Nations. So there are 5 members in permanent Security Council. So who is the 5 members in Security Council with the veto power? UK, USA, France, Russia, China. These are the most powerful countries in the world which dominates in United Nations. Okay, let us see what is International Court of Justice and International Criminal Court. The difference we'll see. It is a part of your 5th unit. The full form ICJ means International Court of Justice, whereas ICC, International Criminal Court. So International Court of Justice, which is established in 1945, whereas International Criminal Court, which is established in 2002. So International Court of Justice, the location is in Hague, Netherlands, whereas International Criminal Court, it is Hague, Netherlands. Both are in Netherlands. Whereas it is a part of UNA. Yes, International Court of Justice is part of UN. It is a main judicial organ. Like International Criminal Court, it is an independent body which is not the part of UN. Okay, it deals with disputes between the states. Also, International Court of Justice, when the different countries have the disputes, then they can appeal to the International Court of Justice. Whereas ICC, International Criminal Court, it is crimes of individuals, not nations. International Criminal Court is meant for the individuals, not for the nations. jurisdiction. So continuous cases and advisory opinion. So if something contention, something bad happened that case, or it also give the advisory services. Whereas ICC, International Criminal Court, deals with the war crimes, genocide, crime against humanity. So International Court of Justice has 15 judges, whereas International Criminal Court has 18 judges. So yes, International Court of Justice, India has a member, whereas International Criminal Court, so it is not the part of the thing India. So the key statutes are United Charter plus International Court of Justice statutes, whereas International Criminal Court is ruled by the Rome Statute or Law 1998. So what you have to remember, International Court of Justice, okay, it is only states can bring case, only countries can have the disputes and they can appeal to the International Court of Justice. Individuals cannot in International Court of Justice. Whereas ICC, so it is only for the individuals are tried, and whereas like governments cannot be prosecuted in International Criminal Court. Okay, so ICJ, International Court of Justice, for the states or governments or for the countries, whereas ICC, it is against individuals. Okay, so like both are in Hague, Netherlands. You have to remember. Then, what is the specialized agencies in the United Nations? Okay, there are different organizations are there. I'll read out. Okay, so one is ILO, that is International Labour Organization, the headquarters in Geneva, so which works for the rights and labor standards. Whereas FAO, that is a Food and Agriculture Organization, the headquarter in Rome, and main work is food security and agriculture. Whereas UNESCO, what is UNESCO? United Nations Educational, Scientific and Cultural Organization, the headquarter in Paris. The main work is education, science and culture. World WHO, there is a World Health Organization. It is also in Geneva. So it is look after the global health. IMF, there is a International Monetary Fund. Okay, so which is in Washington DC. It is look after the financial stability of the world. Whereas World Bank, it is a international bank for reconstruction and development, so which is located in Washington DC, and it gives the loans for the developmental things. Then ICAO, the International Civil Aviation Organization, which is there in Montreal. Okay, it is for the civil aviation purpose. And IMO, International Maritime Organization, it is in London, so which look after the shipping and maritime. So try to remember what is health organization, what is International uh, Labor Organization, and UNESCO, that is a United Nation and scientific cultural thing. So mostly they may ask in the examination. So these are the specialized agencies. Okay, try to take the screenshot and read, that will be good. Then, so some of the key things are there. If you have the patience, I am ready to revise. What is PIL? Okay, okay. This PIL is like relating to the like law between states and so these are the things. Go through this one. Okay. So what is PIL? It is a public international law. What is ICC? International Criminal Court. What is VCLT? It is Vienna Convention of the Law of Treaties. What is UNCLOS? United Nations Convention of Law of the Seas. What is CHM? It is a common heritage of mankind. What is ICAO? International Civil Aviation Organization. What is UNDH? Universal Declaration of Human Rights. What is ICSCR? That is International Convent on Economic and Social uh, Cultural Rights. What is OST? Outer Space Treaty. What is WHO, World Health Organization? What is FAO, Food and Agriculture Organization? What is ICJ, International Court of Justice? What is ILC, International Law Commission? What is VCDR, Vienna Conventions of Domestic, Domestic Relationship? What is EEZ, Exclusive Economic Zone? ICA, International Seabed Authority? What is COPUS, Committee on Peaceful Uses of Outer Space? What is ICCPR, International Convention on Civil Political Rights? What is PAS, P5, that is Permanent Members of Security Council of United States, that is the United Nations, USA, UK, France, Russia and China. What is IMO, International Maritime Organization? What is UNESCO, United Nations Scientific Cultural Organization? What is ILO, International Labour Organization? So this is the thing. Go through this video again and again so that you can clear your exams. Thank you for watching. All the best for your coming examination.